We could take the hard line and say it was a gift, analogous to child support payments. If he doesn't make a child support payment and yet buys the child a bicycle or an automobile, then that's viewed as a gift, and he still owes the support.
You're getting ready to get hammered on this one.
And we're off the record here while we're talking about this. So in the divorce, Mr. Shavita was ordered to pay some money to Miss Shavita, and he made some payments, and there was a deficiency of $19,686.36, and Miss Shavita was ordered to pay a Discover card debt of $17,686.36. And so Mr. Shavita paid that directly. So looking at first, just the credit card debt's the only thing I want to talk about for getting started.
Okay.
And when I looked in the divorce decree, I see there wasn't a specific timeline that, it didn't say that Ms. Shavita is supposed to pay that Discover card in 30 days or 60 days or whenever, but she was responsible for paying that debt. And if I understand the pleadings, that debt is now paid off. So just as far as the amount that would have gone to Discover, the $17,686.36. So Mr. Childers, just kind of tell me what's the harm on that, since instead of paying it to her, he just paid the credit card company.
Well, the harm is that she doesn't have that money in her account. She had made arrangements with Discover to pay the sum of $300 a month to them by a automatic withdrawal from her bank account, and had been doing so prior to the time that Mr. Shavita paid off the account balance. So that's the harm to her. She doesn't have the use of almost $18,000 in her account. And then by virtue of his not paying the entire amount, then she had to hire me to represent her and spend a bunch of money that she didn't anticipate, didn't want to spend, to go back and collect these funds. In the last 2 days, Mr. Shavita has paid her the $2,000. He's paid her $1,000 by a PayPal account on Wednesday, and then last night, the FedEx delivery was made to her home with a $1,000 check, which we assume is going to be good. But
okay, so that's why I was dividing these into two categories. One, the Discover card bill, the $17,686, and then that other $2,000 that was listed of IRS in a survey. So that's been paid directly to her now.
it has.
Okay, so I didn't bring my calculator with me, but if the agreement Ms. Shavita made to pay a Discover card at $300 a month, putting pen to paper, which is not the best way to do it, that would take about 5 years or so to pay that off. Is that right?
Good length of time, yes, sir. Once again, that was her election to do that, since the decree of divorce merely made her responsible for paying that amount, didn't state any specific terms for payment.
Right. And I see that was not in the decree. So then when I ask about the harm, and you said the harm is she doesn't have the almost $18,000 in her account. But if Mr. Shavita paid her an additional $17,686, how is that not a double benefit?
We recognize that there was a benefit by his making that payment. It's not in compliance with the decree of divorce. He breached the divorce decree by not paying her the full $110,000 on or before October the 30th, as he agreed to. So he just took it on his own to make this payment in a way that was not agreed to, was not part of the terms of the decree of divorce, and so he breached the agreement between the parties. And it may have benefited him, he says in his own pleading, that it helped his credit report by paying that amount off, which we don't know whether it did or not. But he didn't have that election in the divorce decree to make that payment. So there is harm. Ms. Shravda chose to have that money in her account and make payments, which he took that election away from her. So that's, but we certainly recognize, and we even said in our own pleading that we recognized that there was a benefit to her.
Okay. I guess when I'm, reading through this, I'm thinking about, a trial and appeal. And one of the things, judges acknowledge is in every trial that we have, judges commit error. And the question always is it reversible error? So if Mr. Shavada, committed an error by, not paying the money directly to her, but then she gets the benefit of the payment, how is it analogous to a reversible error as opposed to just being an error?
Well, we could take the hard line and say it was a gift, just as it's analogous to child support payments in the event that
Judge, if I can respond whenever.
Yeah, I'll come to you, Mr. Clark, in a minute.
Thank you, Judge.
in the event that an obligor in a child support situation doesn't make a child support payment and yet buys the child a bicycle or an automobile, then that's viewed as a gift and he still owes the support. That's kind of the hard line in this situation, would be to make Mr. Schraub to pay the amount and give Schraub the benefit of his having paid the credit card balance also. And we recognize that would be a double dip, and we're not asking for that. But it certainly would be reasonable to make him pay the amount that Lisa Schraub does not have in her bank account, the amount that he paid to Discover. Let Lisa Schraub to pay him off at the rate of $300 a month, which would make him whole at some point in time. But naturally, he would have to wait for his money, just like Discover would have. But that puts the parties back to where they were before he made that payment on October the 30th. And that's one way of doing it. The other way is to punish him by granting my fees for having to go through all this, to make him, which he's admitted that he at least owed the $2,000, and he certainly was not in compliance with the decree. So if he pays my fees, then the court might feel that that's enough to be done. But we certainly didn't want to come back in here on an enforcement. And Mr. Schraub waited a good long time to pay the $2,000 right the night before trial and the day before trial. He makes these last two payments. So we just lost power. Can you still hear me?
I can hear you.
Great. I'm going to be in the dark for a while, it appears.
Okay.
My building is without power right now.
Okay. All right. So let me switch over and kind of generally, before we get started, hear Mr. Clark.
Judge, this has absolutely no similarity whatsoever to a child support payment. A child support payment is an obligation under the law. This is payment of a monetary amount or a debt. So first of all, Judge, I would point you to our objection that we filed to the hearing today. Under the Texas Family Code, section 9.012, you cannot put someone in jail or hold them in contempt for not paying a monetary debt. The Texas Constitution takes that even further. That's exactly what Mr. Childress is trying to do. He's asking for contempt and community supervision against my client for not paying a debt. He cannot do that. So that leaves him with his alternative pleading, which is breach of contract. And under breach of contract, Judge, as in any other civil case, my client's entitled to at least 45 days notice. As Mr. Childress even references in his motion, he's filing it under a level 2 discovery case, which implies at least a 60-day period so you can conduct discovery before this. So I understand he's in a hurry to do this. I understand that he wants to do it because that's exactly what the decree says. But that's not fair. That's not equitable. That is an unjust enrichment, as we allege. And Judge, my client is also relying on the indemnification provisions of the decree. If there is a debt that Ms. Sharvada is responsible for, after the decree of divorce, if my client pays that debt, then he's entitled to indemnification and offset. Judge, this is not money that was in existence at the time of the divorce. This is money he had to go out and borrow to pay to her. And in the process of borrowing the money, Judge, you're going to hear that this impacted the decision for them to loan him money. He's reached out to her and said, we got to take care of this. She hasn't responded. So he paid this. My client was also told with regard to the survey, Judge, that, you know, there could be a lien put on his property if it wasn't paid. He never asked for the survey. Ms. Sharvada and her attorney asked for it back in the divorce, but it was against his property. So he was told it hadn't been paid. When he found out it hadn't been paid, now he's paid her back that money. So we're dealing with a credit card debt, Judge. That's what we're dealing with. There is absolutely no doubt that she's received the benefit of that. And there's absolutely no doubt that payment to her of another $18,000, Judge, is exactly what you said. It's double dipping. It's not fair. It's giving her a double benefit on this case. And with the huge amount of money she's taken in this divorce, $20,000 is a small portion of it. It's not like she was given only this money in the divorce and then he chose to pay it. This is a small portion of what she's received in the total divorce decree. So, Judge, we're objecting to the hearing today for the reasons I stated above, but in defense of what they're asking for, it is an unjust enrichment. We have filed a counter petition, Judge, alleging that, along with the indemnification provisions, because it's just not right to hit my client for $18,000 twice. And it was impacting him. It was impacting his credit report. And, you know, I understand, Judge, that in a perfect world, everybody takes debts, they refinance them on their own name. They don't have joint obligations after a divorce decree. But in this case, they did. And, you know, Judge, we're asking you, first of all, to deny the contempt under both Texas Family Code and under, you know, established case law, Judge, like the N. McLaren case, which is 467 Southwest 3rd 561, which clearly addresses this issue. You cannot put someone in jail for a debt. You cannot hold them in contempt for not paying a debt. And the family law codifies that as well. But that's essentially what Mr. Childress seeks to do today, Judge, and we just don't think it's fair or equitable.
And under the decree, as far as this Discover card debt, you know, it said that, you know, Ms. Sharvada was responsible for paying the Discover card debt, but there was no, you know, no time period. You know, it didn't have to be paid in 30 days, 60 days, a year, 3 years, 5 years, whatever. So what did, you know, was there anything that Ms. Sharvada failed to do as far as the Discover card debt, you know, on her own?
There's not, Judge, other than it's impacting my credit, my client's credit. affected his ability to borrow money for paying her back this. But, you know, we're not alleging that she has done anything wrong at all, Judge. We're just simply stating that my client paid this as a benefit to her. And contrary to what Mr. Childress says, we've been communicating about this, Judge, for a couple of months now. It's not like, you know, nothing's happened since, you know, last year when this was due to her. But Mr. Childress's first communications on this said exactly what he denied to you. He said exactly that this was a gift from my client to my client's ex-wife. That's what his letters said, Judge. That's simply not the case. And like I said, this is not the entire amount of what she was given in the divorce decree or awarded. This is a very small portion of it. So yes, Judge, there's no harm in this. She can save the $300 a month. She can save the thousands of dollars of interest on it. He paid it directly. You know, maybe she didn't have the ability to do that at this time. He did. And she gets the benefit of it, Judge.
May I
All right.
respond briefly?
Okay, go ahead.
First of all, Mr. Clark didn't file any pleadings until 10:30 on Tuesday night, so none of his pleadings are timely in this matter. We're not asking that Clayton Schraub be placed in jail. There's no request for any jail time. We're very comfortable with the court dealing with the breach of contract issues by themselves and without any of the requests for probation or community supervision or anything like that. So
that's not what his pleading says, Judge.
If I may be allowed to respond without being interrupted.
Go ahead, Mr. Childers.
Then the indemnification clause isn't even relevant because, as the court has already stated, Ms. Schraub hadn't done anything wrong, and Mr. Clark agreed with that. She's been in compliance with the decree of divorce. Mr. Schraub has not been in compliance with the decree of divorce. So this was an agreed date for this hearing. This was Mr. Clark's requested date for this hearing back in January. So we've all had notification from your trial coordinator on January the 19th of 2021. This was our hearing date today. And so to come forward at this point in time and say, well, we're entitled to our 45 days, he's had 45 days. And everybody knew about this. Everybody was consulted, and this is an agreed trial setting. And we would like to dispose of it today.
Okay.
And Judge, that's simply, I'm sorry, that is simply not the case. Counsel asked me if I would accept service on this, and I said, I can't accept service on a contempt case. You're asking for him to be held in contempt and community supervision. I cannot accept service. My client has been served with this matter less than 45 days to today's date. And Mr. Childress seems to think that after the last case was over with, he can just set a date and ask me to agree to it, where I don't know if my client's going to retain me or not. And I was asked for what days I'm available. And this was a date I said I was available. That doesn't mean he's entitled or allowed to set it in contravention of the rules of procedure or the family code. But I mean, this is not an agreed date. When someone serves you with a contempt, you don't have the normal time periods that you have to answer so many days in advance. You know, you can show up the morning of the hearing with a defense, and that's perfectly acceptable when you file a contempt action, which he did.
Okay, well, we're going to go ahead and get started. So now we'll go on the record. So Ms. Lozano, this is cause number 2017L6971, the matter of the marriage of Lisa Shravada and Clayton Shravada. Mr. Childers, first of you to announce yourself and who's here on your behalf.
Your Honor, my name is Craig Childress, and I represent Lisa Martin. And Lauren Gavigan Lloyd is now with us also. She is a paralegal in my office and will be presenting exhibits today. We're ready to proceed.
And what witnesses will you have?
Your Honor, I would call Lisa Shravda or Martin and myself.
All right, and then Mr. Clark, if you'd announce yourself and anybody that you have.
Your Honor, Robert Clark for the respondent Clayton Sharvda, and he is our only witness today.
All right, so if I can get Miss Martin and Mr. Shavit to raise your right hands. Nothing but the truth to help you God. Okay. All right, and before we get started with your first witness, I'll take judicial notice of the divorce decree that was entered in this case. And Mr. Childers, you may call your first witness.
Thank you, Judge.
And if that's Miss Martin, she'll need to unmute herself.
Thank you.
You may proceed.
State your name for us, please.
Lisa Renee Martin.
And Ms. Martin, were you divorced in the county court there in Austin County back in July of 2020?
Yes, I was.
And I'll ask you to look at what has been marked as Petitioner's Exhibit Number 1.
Judge, if I may at this time, Judge, I'm going to make a motion to dismiss his contempt case under Texas Family Code Section 9, specifically 9.012, Judge, which says you cannot hold someone in contempt for payment of a debt under a divorce decree, as he's essentially trying to do. So I'd like to, jeopardy's attached. Now that the first question has been asked and answered, I'd like to make that motion.
So, Mr. Childers, we had some discussion off the record, and my understanding was you were not going to proceed with the contempt, but with the more of the breach of contract. So is that correct?
That is correct, Your Honor.
All right. So then Mr. Clark's motion to dismiss the contempt is granted.
Thank you, Your Honor.
All right. So Mr. Childers, you may proceed.
Ms. Martin, does that appear to be a true and correct copy of the agreed final decree of divorce?
Yes.
And Your Honor, at this time, we would ask, the court's already taken judicial knowledge of it, but we would ask that Exhibit 1 be admitted into evidence.
Okay.
No
All right.
objections, Your Honor.
All right. Exhibit 1's admitted.
Ms. Martin, pursuant to the terms of that decree of divorce, and specifically on page 4, was Clayton Shravda to pay you the sum of $110,000 on or before October 30th, 2020?
Yes.
Did he do so?
No.
How much did he pay you on or before October 30th, 2020?
He paid me $90,313.64.
Okay, and was that also listed on page 8 as one of the liabilities that he had, that he was to pay you that amount? The $110,000 on or before October 30th?
Yes. Yes.
And was he in compliance with the decree when he failed to pay that $110,000?
Yes.
Was he in compliance, or did he breach the decree?
No, he breached the decree. He did not pay me.
And answered.
Objections overruled.
And how did you receive the $90,000?
A check, FedEx.
On what day did you receive that?
On October 30th.
I'll ask you to look at what has been marked as Petitioner Exhibit Number 2 and tell us if that purports to be a true and correct copy of the check that he sent to you.
Yes.
Your Honor, we would offer into evidence Petitioner Exhibit Number 2.
And no objections, Judge.
Petitioner's 2 is admitted.
I'll ask you to look at Exhibit Number 3 and tell us what that is, Ms. Martin.
That is just a check. He's showing that he paid the Discover bill, but he paid it, I guess, online, but he wanted to show me that he paid it.
So is that a check that you received along with the $90,000 check on October 30th, 2020?
Yes,
You recognize his handwriting?
yes,
Does that instrument bear his handwriting?
Judge, we
yes.
have no objection to Exhibit 3.
Okay, Exhibit 3 is admitted.
Ms. Martin, I'll ask you to look at Petitioner Exhibit number 4 and tell us what that is, please.
That is the letter that he included with the check. But in the letter, it says that he tried to contact me and he did not.
Objection non-responsive.
Objection sustained.
Your Honor, we would offer Petitioner's Exhibit number 4 into evidence.
No objection.
Petitioner's 4 is admitted.
Ms. Martin, go ahead and read that for us, please.
Objection, Your Honor. The document speaks for itself.
Yeah. Objection sustained. Yes, I can read that, and it was in the file, so I've read that.
Thank you, Judge. Down at the bottom, Mr. Clayton has written a little summary of what the amounts are for. And one of those amounts is for the $17,686.36. Was that the amount that corresponds with Exhibit number 3, which was the payment to Discover card?
Yes,
And the $2,000 in the third line of that computation was deducted from the $110,000, was it not?
yes,
Has he since paid that?
yes.
And tell the court how that was paid to you.
$1,000 in a PayPal account, which was yesterday, and then also a written check from his personal account, FedEx to me yesterday.
So you received the FedEx check last night.
Yes,
Have you negotiated that check yet?
no,
But you're willing to accept both of those as payments toward the amount that is owed as a result of the original decree of divorce and the lawsuit that we had to file.
yes,
Do you hire me to represent you in this matter?
yes,
Did you agree to pay me $400 an hour to represent you to get the funds restored to you that were owed as a result of the decree of divorce?
yes,
And are you asking the court to grant reasonable and necessary attorney's fees for the purpose of litigating this matter and getting you paid?
yes,
And at the time that the account was paid off to Discover, had you been making regular payments to Discover?
yes.
What were those amounts?
I started making the $300 payments in April of 2020 as temporarily until I got the full settlement of 110. At that time, I was to call the
Objection non-responsive.
representative.
Objection overruled.
May
You
I
may answer.
explain? At that time, I was to call the representative and we were going to negotiate a settlement on that Discover card. I was not going to have to pay the full amount, but Clayton
Objection, hearsay.
intervened.
Objection non-responsive.
Objection sustained as to hearsay.
Can I continue? Or?
No. But so as a result of the payment that Clayton made on that credit card, did you lose the ability? How did that affect your ability to negotiate with Discover?
Objection, Your Honor. Leading objection assumes facts not in evidence and calls for speculation.
Okay. Objection's overruled.
You may answer.
He took away my ability to settle that Discover card with the representative because he paid it on his own. That was my account. And in the 3 years,
Objection, non-responsive.
Objections overruled.
in that 3 years, all Clayton had to do was email me and have me remove him from the account, and it would have never affected his credit, but he never asked me to remove him. This was my account, not his. That's why it's in the decree that I was to take care of it, but he took that privilege
Objection,
away from me.
non-responsive.
Okay, objections overruled.
He took the privilege away from me by, I wouldn't have had to pay that full amount. And the $300 was just a temporary agreement I had with the credit card company until I got the full amount.
So what are you asking Judge Leedy to do this morning?
I'm asking Judge that our divorce went on for 3 years, and I don't understand why you go through this.
Objection, non-responsive.
Objection sustained. Just answer the question directly, what you're asking me to do.
I'm asking you to have Clayton pay me the remaining amount that he owes me, because the Discover card, per the decree, was not his responsibility. It was mine. And he took that away from me to do what I was supposed to do, my responsibility. So I'm asking you for him to pay me the remaining amount of money. He took that upon himself to make that decision.
Objection, non-responsive.
Okay, objections overruled.
You told us what to do in the decree, and I followed it, and he did not.
Have you paid me approximately $3,300 in this matter, the $2,500 retainer, and then another $800?
Yes, sir.
You're asking the court to reimburse you for the amount that you paid, and also to award you fees for the balance of my fees that are owed at this time?
Yes.
Judge, I'm sorry, I'm going to object. Someone keeps sharing the screen on things that are not admitted into evidence. I'd ask that the screen share be turned off until such time as something's being offered.
Okay. All right. That's granted.
Your Honor, I pass the witness.
All right, Mr. Clark.
Yes, ma'am. You just stated something. I just want to make sure I understood. It was not his responsibility in the decree to pay the Discover card debt. It was yours, correct?
Yes.
And ma'am, as you've been talking about this morning, you have not paid it in accordance with the normal terms of that credit card, correct? You
Your Honor,
negotiated
that's not relevant.
Okay, objections overruled.
Ma'am, you negotiated $300 a month to pay them, correct?
Temporarily.
Correct?
Yes, until
Okay, and so ma'am, if all you had to do was call up Discover and tell them to take Clayton off of the credit card, why didn't you do that at the time of the divorce?
because I didn't know it was affecting his credit. It was his
Okay,
responsibility.
well, ma'am, he tried calling you to talk to you about this and texting you, correct?
Clayton knows I blocked his cell phone in 2017. He knows that.
Okay, so my client's supposed to, oh, okay. So ma'am, let me make sure I'm clear on this. There is a obligation that he is responsible for, even though you were awarded that debt in the decree, correct?
No,
Ma'am, the credit card was coming after both of y'all, correct?
no.
Judge, that's been asked and answered.
Well,
Objection overruled.
No,
Why is it on his credit report if they're not after him as well?
Judge, that
They-
assumes facts that aren't in evidence. I'll object to it.
Objections overruled.
Okay.
it was my credit, not his.
Okay. But ma'am, you told Judge Leedy just a few minutes ago that all you had to do was just call up the credit card company and say, take him off. Why didn't you do that at the time of divorce?
I said,
Objection,
He-
Your Honor, that's outside the terms of the decree, and she wasn't.
that's not my
He's trying to-
responsibility.
And Ms. Shravita, when there's an objection, you need to stop because the court reporter can just get one person at a time. So
He didn't, our objection is she didn't have the duty to, under the terms of the divorce decree, to make that call.
And Judge, this gets into the indemnification provisions of the decree.
objections overruled.
So ma'am, you simply could have called the credit card company at the time of divorce and taken him off. Is that your testimony?
I did not know he was on the
Objection,
credit.
non-responsive.
No,
Ma'am, you just stated to Judge Leedy a few minutes ago that if he had emailed you or texted you and asked you to take him off of this,
if
At any
he
time-
would have asked me.
Okay,
if
and
he
Ms.
would have-
Shravita, you got to wait until a question is completed and then you answer. So Mr. Clark, if you want to re-ask your question.
ma'am, a few minutes ago, you just told Judge Leedy that if he had simply asked you to take him off the account, you would have done so. And then now you're saying that
Yes,
there's no way for him to contact you because you blocked his number, right?
email. He could have emailed me.
Okay.
Email.
Ma'am, is there any doubt whatsoever that you now have gotten the benefit of the $18,000 credit card payment?
Yes,
You haven't gotten the benefit of the $18,000 credit card payment?
yes, I have.
Okay, thank you. Ma'am, have you looked at your divorce decree, which is Exhibit 1 on both page 7 and page 17? Have you looked at those, ma'am, where it gives you an obligation to indemnify Mr. Sarvda for your debts and obligations?
Yes,
Why can my client not rely on what y'all agreed upon as to you indemnifying him for his debts, for your debts?
Your Honor, that assumes facts that aren't in evidence. There's been no demand for indemnification in this matter. There's been no proof that failure to indemnify.
Objections overruled.
Ma'am, should my client be allowed to rely upon the terms of the divorce decree as to the indemnification? Yes or no?
I don't understand.
Ma'am, should my client be allowed to rely upon the terms of the divorce decree? Yes or no?
Yes, he should rely on the
Okay.
divorce decree.
Thank you. And ma'am, is there any dispute whatsoever that if you get another $18,000 awarded to you by Judge Leedy, that you have essentially gotten paid twice for the same amount?
No,
No other questions, Judge. Pass the witness.
Mr. Childers?
No further questions, Your Honor.
All right. So Mr. Childers, do you have any other witnesses?
Just myself for attorney's fees.
You may proceed.
Thank you. Your Honor, my name is Craig Childress. I've been practicing law for 47 years, primarily in Harris County, but also in at least another 50 counties in the state of Texas.
Judge, we'll stipulate as to his qualifications.
Thank you. With reference to this matter, total fees generated are $4,758.84. Ms. Shravda has paid $2,500 to date, plus another $800 for $3,300. We would ask that, I believe that that's a reasonable and necessary fee for representing Ms. Martin in this matter. Mr. Shravda has made the admission that he owed at least a portion of these funds by making the payments, half of it on Wednesday and the other half last night. And we would ask that the court award Ms. Shravda the total sum of $5,300, $53,58.84 for my representation of her in this matter. And I pass the witness.
Mr. Clark?
I'm confused, Mr. Childress. You submit an exhibit to this court for a $2,000 amount for attorney's fees, right?
Well, no, and actually,
Yes or
let's
no?
go back and
Yes or no?
offer that admitted. It hadn't been admitted, so you're going to question me from the exhibit. Let's go ahead and admit it.
Sir, I'm just asking you. You originally had a $2,000 amount, correct?
You're asking me to testify from a document that hasn't been admitted into evidence, so let's go
No,
ahead
sir,
and
I'm
admit
asking
it.
you to testify from your own knowledge as to how much fees and expenses you incurred in this matter.
Your Honor, we would offer petitioner exhibit number 5 into evidence.
Yeah, right now, I guess, Mr. Childers, you're on cross-examination, so when you get back to a redirect, you can do that.
Thank you.
Sir, didn't you originally, what is the amount you originally asked for? 2,000 something?
No, that's the balance due. The entire amount,
No, sir. The original amount you asked for in the divorce decree was a $2,000 number, correct? Or, I mean, in your motion, I'm sorry. Hello?
I'm gonna have to review the motion. If you're asking
Okay.
about a question that pertains to the motion, no, that's not correct.
What's the amount that you asked for in the motion for enforcement by contempt?
It doesn't state a specific amount.
Didn't you attach your fee statement to the end of it?
It says reasonable attorney's fees. That's what's
No,
requested
sir.
in the motion.
Didn't you attach your fee statement to the end of your motion?
No, I did not.
Okay. Well, Judge, the court has that information in front of it. And then, sir, a few minutes ago, you testified that your clients incurred, through her testimony, $3,300 of fees, correct?
No, she's incurred more than that. She's incurred,
No, sir, that's not my question. Your question to her is you've incurred $3,300 of fees, $2,500 plus $800, correct?
that was not my question to her. My question was how much she had paid so far.
And so now, here we are, you're asking for $5,358.84, correct?
That's correct.
And sir, when you contacted us after this matter first became an issue, didn't you clearly state to us that this amount is considered to be a gift from my client?
Said it could have been considered a gift.
No, sir, your letter says it is a gift. You are considering it a gift, correct?
Not looking at the letter, whatever the letter says.
Okay, well.
You're
that's
talking
what-
about the demand letter. Let's put the demand letter into evidence.
Sir, you had the ability to do that. This is your case. No other questions for this witness, Judge.
Mr. Childers?
Your Honor, at this time, we would offer petitioner's exhibit number 5 into evidence.
Any objection?
Judge, I've not seen Exhibit 5. I don't know what it is.
Lauren?
Ms. Gavigan can put Exhibit 5 up. All right. Any objection to Exhibit 5?
In the way that he's offered it, Judge, yes. He hasn't He hasn't laid a predicate for it.
So, Mr. Childers, do you want to lay the predicate for Exhibit 5?
Be glad to, Judge. Your Honor, I'm the custodian of the records for my office. The entries on that document are made at or near the time that the event occurred. It is a true and accurate reflection of the time that was invested in this preparation for this proceeding.
Judge, if his testimony is if it's a shorthand rendition of his testimony, that's sufficient. He just hasn't said it.
All right, well, is there still an objection in number 5?
Not if he says it's a shorthand rendition of his testimony, there's not.
It is a shorthand rendition of the testimony that I would give to prove it up as a
No objection.
business record.
All right, then Exhibit 5 is admitted.
Your Honor, we rest.
All right, and Mr. Clark.
Well, Judge, I would ask for a judgment on his attorney's fees because there's been no testimony from him at all that they are reasonable and necessary and customary. So I would ask for judgment on that issue, Judge, now that they've rested.
Let's hear the rest of the case and then I'll consider that.
All right. Judge, I would call Clayton Sharvda.
Okay, you may proceed.
Sir, state your name for the court. After taking yourself off of mute. There you go.
Wayne Sharvda.
And sir, you're the respondent in this matter, correct?
Correct.
And you were a party to the original divorce decree, correct?
Correct.
Sir, what we're here today about is what's left over is the credit card bill to Discover, true?
True. Correct.
Sir, how did you get the money to pay Ms. Sharvda the check that you previously delivered to her for the $90,000 amount?
Objection, Your Honor, that's not relevant.
Objections overruled.
I had to borrow the money.
And sir, what did you learn, if anything, when you were in the process of borrowing the money?
Objection, hearsay.
I asked him what he learned, Judge, not what he's heard from someone.
Okay, and if we have to hear what his testimony is, but if the testimony includes what somebody else told him, then the objection is sustained.
Okay. I have documentation, which is not an exhibit, but I learned it through my credit report that was on there.
Okay, and sir,
Objection to hearsay, Judge.
Yeah, objection to hearsay sustained.
okay. So, sir, after you tried to get a loan to pay this amount and you found out you're still responsible for the Discover card, what steps, if any, did you take to contact the movement about resolving this matter?
I had text Miss Lisa Martin, Sharvda, whatever she goes by, numerous different times, a couple of times. Obviously no response, which just assumed she wasn't responding to me. So then finally I made the call to Discover and made the payment, trying to do the responsible thing, because otherwise it was, I didn't know
Objection,
anything
not responsive.
No.
Objection overruled.
I did not know anything of the Discover bill or the credit card, and upon my refinancing of my house to pay her the final payment. So,
Okay, so sir, you've heard her testimony today that she's trying to do something different than pay the card according to its normal terms, correct?
yes, I don't understand that. Yeah.
Okay, but sir, in the divorce decree on both page 7 and 17, she's obligated to indemnify you, is she not, for her debts?
Yes.
Which means if you have to pay her debts, she needs to pay you back, correct? That's the shorthand version of it.
Yes.
Is that what you're asking Judge Leedy to consider today in the resolution of this matter?
Yes.
So to be absolutely clear, Mr. Sharvda, was the $18,000 credit card payment a gift to her?
No,
And in fact, when you made it to her, you certainly stated it's not a gift in your letter, did you not? That's already in evidence?
that's correct.
Yes, sir. Also, there were some other payments in there that we just lost you off screen, sir. Are you still with us?
Yes, sir. Yes, sir. Hang on. I'm coming back. Okay.
There was another $2,000, which was a $1,200 bill to the surveyor and the penalty and interest payments you had to make on the Social Security payments for, or the IRS payments for both of you, correct?
That is correct.
Now, once learning that the surveyor was incorrect and that that money had already been paid, you've now reimbursed that back to Ms. Sharp, correct?
That is correct.
As well as just to stop the sake of arguing the IRS penalties as well, correct?
That is correct.
So the only thing that's remaining is just the credit card debt, correct?
That is correct.
If Judge Leedy orders you to pay her another $18,000, is that fair?
No,
Is that an unjust enrichment to Ms. Sharvada?
yes,
And it basically pays her twice for the same thing, correct?
correct. What she was negotiating anyway.
So, sir, it is definitely a direct benefit to her that you paid the Discover card, correct?
Yes, it is.
Mr. Sharvada, and we've been going back and forth with counsel on this for months, have we not?
Yes, we have.
Are you asking Judge Leedy today to just dismiss the case and to find that both of y'all have settled up with each other and to go forward and live your lives?
Yes, I am so much.
You heard her testify to the judge a minute ago that the divorce took 3 years. Is there any reason to drag this out any longer?
There is not.
Is there any reason to fight anymore for this?
No, there is not.
Nothing further, Judge. Pass the witness.
Mr. Childers?
Just briefly, Your Honor. Mr. Shravda, you were aware of the terms of that divorce decree wherein you were to pay Lisa Shravda the sum of $110,000 on or before October 30th, 2020. Were you not?
How to answer that is no, until these proceedings came along. I thought I was doing the most
Objection,
responsible.
not responsive.
Objection.
Yes or no, Mr. Shravda? Do you understand the decree?
No,
So you didn't understand from the terms of that decree that you were to pay Lisa Shravda $110,000 on or before October 30th, 2020. Is that what you're telling this court?
in hindsight, yes.
Did you read the decree?
Objection, Judge. Argumentative, relevant.
Objection sustained.
Well, in the letter that's exhibit number 4, you acknowledged that you were to pay her $110,000, did you not? In your
Yes.
little computation in the lower left-hand corner.
Yes.
Mr. Shravda, if you had paid her that $110,000 on or before October 30th, we wouldn't be here today having a hearing over this matter, would we?
Objection, Your Honor. Speculation. Objection, relevance.
Objection sustained.
Mr. Shravda, you, in responses to Mr. Clark's questions about this matter being dragged on even past the date of divorce, the only reason it's been dragged on is because of your failure to comply with the terms of the decree and pay that $110,000 on October 30th, 2020. Isn't that correct?
Objection, Judge. Relevance. Objection, Judge. Argumentative.
Objection sustained.
Oh,
When I sent you a demand letter back in November of 2020, you didn't even pick it up. You didn't even accept the certified mail, did you?
Objection, Judge. Relevance. Objection.
Objection sustained.
Did you receive the demand letter by regular mail also?
Judge, we'll stipulate that we received the demand letter because it was also emailed to me as well.
All right, so I'll approve that stipulation.
Thank you.
And this is the letter, Judge, that said it was a gift also.
Mr. Schreiber, the bottom line is you didn't comply with the terms of the decree, did you?
Objection, Judge, calls for a legal conclusion and speculation on my client's part.
Okay, objection sustained.
Mr. Schreiber, you did not pay Lisa Martin the sum of $110,000 as agreed to on October the 30th of 2020, did you?
Yes, I did.
Are you saying that you wrote her a check for $110,000 on that date, on October 30th?
Not directly to her, no.
You only gave her a check for $90,000, $313.64. That was the only direct payment that you made to her
That is correct.
until the last $2,000, which was paid $1,000 on Wednesday and $1,000 yesterday.
Objection, Judge, asked and answered, repetitious.
Objection overruled.
You may answer.
A yes and no answer. Please ask the question again.
Other than the $90,000 check that you gave her on October 30th, you did pay her another $2,000, $1,000 on Wednesday and $1,000 on Thursday of this week, acknowledging that those amounts were owed, did you not?
As acknowledged by my counsel, yes, we
No,
did pay
sir,
that.
by you. You wrote the checks, didn't you?
Objection, Judge, you just asked and the question's been asked.
Okay, objection sustained.
Your Honor, I pass witness.
Mr. Clark?
Just a couple of follow-ups. Sir, when you were saying that you thought you were following the terms of the decree and what you were doing, were you relying upon the decree and the specific terms in there for indemnification?
Yes.
Nothing further, Judge.
All right, anything else, Mr. Childers?
Your Honor, the question came up about my testimony as to the fees being reasonable, necessary, and customary. I do believe that I testified to their being reasonable and necessary. If I have to reopen to provide that testimony to the court, I'd be pleased to do so.
Okay, I think exhibit 5 was admitted, so that evidence is in the record.
Thank you.
Okay, Mr. Clark, anything else?
Judge, I'd call myself real quick as to the issue of attorney's fees.
Okay, you may proceed.
Judge, my name is Robert Clark. I'm a licensed attorney by the Supreme Court. I'm in good standing, have been at all times since institution of this case. I'm also board certified in the area of family law and routinely practice before the courts in Austin County, Texas, and know the amounts and the customary fees charged by lawyers with my level of expertise in these matters. In fact, I think Your Honor probably remembers I was in front of you in another matter real recently with a different attorney. So, Judge, the amount being requested by Mr. Childress is not reasonable and necessary. It is not directly connected to this matter, and it is inflated, in my opinion, due to his intransigence and his client's position from the very beginning in this matter as to characterization of my client's payment. And so, Judge, I would submit that to the court, that in my expert opinion, his fees are not reasonable and necessary. And I rest to pass myself.
Mr. Childers?
Your Honor, we have no questions of Mr. Clark.
All right, well then, and both sides have rested. All right, well then, based on the testimony that's presented in this case, I will deny judgment in the amount of $19,686.36. Deny attorney's fees. One thing I'll just put on the record to make sure Mr. Shavada is aware that I understand that a personal check was given to Ms. Martin yesterday for $1,000. And as long as that check clears, then that should satisfy that obligation under the decree. If that check would bounce, that could potentially be a Class A misdemeanor, which would subject him to a fine up to $4,000 and up to a year in the Austin County Jail. So again, the fees, the money judgment is denied. I will award Ms. Martin a judgment for the fees that she had, the costs, I'm sorry, that she had to pay for this case to be initiated, looking at Exhibit 5 with the service fee, the filing fee, and the FedEx fee. Looks like it's $608.84. So I award Ms. Martin a judgment, the amount of $608.84, and that's to be paid by April 30th, 2021. So anything else, Mr. Childers?
Do we have an entry date for that judgment?
April 1st at 1:30.
All right, sir.
All right, anything else, Mr. Clark?
No, sir, Judge. I believe that has it all.
All right, thank you. You're all excused.
Thank you, Judge.
Thank you, Your Honor.